Hello, and welcome back to Business Law Online. We're going to be continuing our discussion on different types of business organizations. This lecture, we're going to focus on limited partnerships and limited liability companies. When we last left off, we were talking about partnerships, and we had just briefly touched limited partnerships. Um, so, uh, and what we're doing is we're moving along the spectrum from the easiest to set up, but really the hardest to raise money for, a sole proprietorship, to the more complex and expensive to set up, but the easier it is to raise money. So, for instance, with a partnership, although there are no formal filing requirements with a state agency or government agency, you do have to satisfy those four criteria. And it is important that you know those four criteria. Voluntary association of two or more people, carrying on a trade or business or profession with the intent of making profit and acting as co-managers. All right, so going to limited partnerships. Now, limited partnerships are different from general partnerships uh, in one really big fundamental way. With a limited partnership, you have two types of partners. You have a general partner and you have a limited partner. So I want to do a little side-by-side comparison of the two types of partners. With a general partner, they contribute capital. It could be money, expertise, services, equipment, whatever the case may be. A limited partner also contributes capital, money, expertise, equipment, whatever the case may be. A general partner can manage, can run the business, has a say in it. A limited partner cannot. A limited partner cannot run the business, does not have a say in how the business is run, cannot make business decisions. The only thing a limited partner can do is vote. Finally, with that in mind, why would anyone be a limited partner? Well, with a general partner, they have 100% personal liability for any debts, liabilities, or obligations incurred by the partnership. A limited partner, though, their liability is limited strictly to their capital contribution. Now, with that in mind, um, you can see why it might be a little bit easier in a limited partnership to raise money. For instance, the New York Yankees are a great example of a limited partnership. George Steinbrenner, throughout the years, sold uh, limited limited partnership shares of the New York Yankees to investors, and it's attractive for someone who wants profits. Limited partners are entitled to the profits, but don't really want to run a business, and they don't want the personal liability of running a business. So it's kind of like an extra tool for raising money. You don't have. We'll sell you a share of our partnership. You don't have to be a general partner and thus be responsible for running the business and being personally liable for partnership debts. You could be a limited partner. You won't have a say in running the business, but your liability is limited just to your capital contribution, and you're entitled to the profits. So in a sense, it's attractive for some people just to be a limited partner if they're looking, for instance, for income. So you can see how that's like an extra tool to form to raise money. Limited partnerships are governed by the Uniform Limited Partnership Act. It's been adopted by basically all 50 states in one form or another. States may call it one thing or another. But limited partnerships are a little bit more formal to form. There is a state filing required. You have to file a certificate of limited partnership with the state. And what has to be in that certificate of limited partnership? Well, one, the name of the limited partnership, and it should have LP or limited partner or something indicating it is a limited partnership. The general character of the business should also be in the certificate of limited partnership. Again, I like to keep that um, as broad as possible. Uh, the address of the principal place of business of the limited partnership, plus the name of the agent designated to receive process. What does that mean? Well, clear and simple, all it means is this. What is process? Process usually means you're being sued. When you sue somebody, what do you have to give them? You have to give them that summons and complaint. The plaintiff has to deliver the summons and complaint to somebody. That's process in the broadest sense of the word. So the limited partnership has to have an agent, someone who is designated to receive that summons and complaint, someone who is designated to receive that process. So that has to be included. The name and address of each general and limited partner. The current and future capital contributions of each general and limited partner. Why? Well, after all, limited partnership, if you're a limited partner, it's all about that limited liability. So you got to state somewhere, what is your limited liability? How much have you actually contributed to this limited partnership? And further, because this document, the Certificate of Limited Partnership, can act as the limited partnership agreement, anything else that the general or limited partners think is pertinent regarding running the limited partnership. So with that in mind, you have a certificate of limited partnership that's got to be filed with the state, and that can serve as your governing document for the limited partnership. But you can also have a separate limited partnership agreement. Again, there's no requirement that you have one. Your certificate of limited partnership may act as one if you include the provisions that you want in it. But regardless, if you have a certificate of limited partnership, if you have a limited partnership agreement, what should be in those documents if you want them to act as your governing document for the limited partnership? Well, basically anything that's in a partnership agreement, an ordinary partnership agreement. The only thing, of course, is what? What about the duties and responsibilities of the limited partner? Can they have a lot of duties and responsibilities? Of course not. The whole point of being a limited partner is they have no duties or responsibilities. The only responsibility they have is to vote. That's the only power that they have. So if you are going to have a limited partnership, the limited partner probably wants to make sure in the limited partnership agreement or the certificate of limited partnership, maybe even the state specifically, the limited partner does not have any managerial responsibilities with respect to the business. By the way, what would happen if a limited partner started to get involved in running the business? Well, that could threaten the limited partner's limited partnership status. What does that mean? From a legal point of view, they cease being a limited partner and become a general partner. That means what? Their personal liability is 100%. They have 100% personal liability for all debts and liabilities incurred by the limited partnership. So, if you are a limited partner, try not to get involved. All right, limited partnerships are another great form of business organization. There are also limited liability companies, LLCs. Now these start to get a little bit more complex, and they really combine a lot of characteristics of partnerships, limited partnerships, and even corporations. They're really a hybrid between all of them. Limited liability companies, or LLCs, are governed by the Uniform Limited Liability Company Act. An LLC is a distinct legal entity. Okay. Now, the owners of an LLC, they're referred to as members. They're not shareholders, not stockholders. They're not partners. They're not a sole proprietor. They're referred to as members. Now, members, LLCs combine a couple of different characteristics. For one thing, for instance, the liability of its members is the same as a limited partner. So a member of a limited liability company, their personal liability is limited to their capital contribution. So that's a pretty good thing, obviously. And in terms of the liability of the LLC, it's very similar to a partnership. If one member commits a tort, or signs a contract, then potentially all the members are liable for that tort or contract. But of course, only to the extent of their capital contribution. So you can really see that LLCs are a combination of ordinary partnerships and limited partnerships. Another interesting thing about LLCs is you don't have a partnership share, but LLCs issue. Now, certificates of interest, little pause there, sorry.
Stock exchanges. You can buy an LLC certificate of interest on many exchanges. I've seen them listed on the New York Stock Exchange. So in that respect, they're kind of like corporations, which we'll talk about next lecture. That's going to be a longer lecture. So that's something to keep in mind too about limited liability companies. Now, the interesting thing about a limited liability company um, is that you can have members, but you can also have non-members, non-member investors. And what they do is they invest money, and they don't own the LLC like a member, but they have a right to profits. It's basically a profit share. They have a right to profits. They buy into it, and they can get whatever it is, 10%, 20% of the profits for that LLC for the year, whatever the case may be. But if the LLC is sold, they're not owners, so they don't get capital gains. They don't see an increase in their principal, so to speak. So in that respect, it's not like stocks. But again, you can see that there's an extra avenue in which to raise revenue. They can sell profit interest in their LLC. Now, forming an LLC is complex. There is a state filing. You have to file articles of organizations with the state, and in the articles of organizations must be the name, including in the name limited liability company, LLC, something designating that it is in fact a limited liability company. Two, you can state the duration. You could state in perpetuity, forever. That's fine. Three, the names of the members. And four, any other information the members think is important because it can serve as the governing document for the LLC. Now, the LLCs have to make one really big important decision. When you form an LLC, the members have to decide whether or not they're going to be member managed or manager managed. Now, if they decide to be member managed, what that means is that all members have a right to sign a contract to conduct business on behalf of the LLC. Now, all members can then thus contractually bind the LLC. If they decide to be manager managed, what they've done is they've decided to elect one or maybe a couple of members to run the LLC, to run the business, make business decisions, and enter into contracts. Now, if they decide to be manager managed, only those managers can sign contracts on behalf of the LLC. The other members cannot. But the flip side is if it's manager managed, those non-manager members do not owe the LLC a fiduciary duty. That's something important to keep in mind. If it's member managed, then of course they do owe the LLC a fiduciary duty. And remember, a fiduciary duty, that's a duty, that's an obligation to put someone else's interest, a third party's interest, ahead of your own. As a matter of fact, you can only take into consideration the best interest of that third party, in this case the LLC. So if it is member managed, the members still owe the LLC a fiduciary duty. If it's manager managed, the non-manager members do not. All right, so that's LLCs. The next lecture will be corporations. We're moving along the semester, and keep up with the work. We're almost there. Just a few more weeks to go. I'm pleased with the class. I'm pleased with the progress. I know it's tough, but these courses require a lot of discipline, a lot of self-discipline. You got to listen to the lectures more than once usually, and you have to keep up with the work. But keep up the good work. And if you have take good notes, and if you have any questions, please feel free to email me.